Okay, here we go. Your meeting is being live streamed.
Okay, yeah, I figured that one out.
Okay.
I just have to mute it. Give me one. So, okay. All right. I am so sorry, Madam Chair. I think I am all set. One thing with the OneNote, there's a couple Idaho statutes that I pulled up that I saw referenced in some other documents that I have not yet put in the OneNote, but I'll be doing that as the meeting progresses. But I think we're fine without that right now. All of the major documents are in there.
Okay, sounds good. So I see two hands up. We've only got one real item on the agenda for tonight besides public comment. Let's see here. So if you're comfortable with it, Madam Secretary, I'm going to go ahead and call us to order.
Yeah, I'm comfortable with that now.
Okay, so I'm calling us to order at 5:14 p.m. Pacific time, so 8:14 p.m. Eastern time. Should we do public comment first, or should we jump right into roll call?
That is entirely up to you. I can do it either way. This way it would give LNC members maybe who are having some difficulty time to get here if we did roll call afterwards.
Okay, so why don't I only see two hands raised for public comment. So at this point, I'm inclined to do 2 minutes for public comment each. And depending on how long this meeting goes, we could do 1 minute again at the end. That works for me. So why don't we go ahead and do that? And then we'll do roll call after public comment.
Okay, perfect. And do you need anything from me for public comment, Madam Chair?
Do you have the ability to mute and unmute people?
I can ask them to unmute. I think they can unmute themselves. So once you call on people, I can hit the ask to unmute button and that will prompt them to unmute.
Okay, so that works for me. I want to make sure that people aren't talking over each other as we get into the meeting later. That's why I asked about the muting capabilities. But if everyone will be chill, that sounds great and we don't have to deal with that. So why don't we hear from Ms. Imhoff first, because her hand is up first. She's first in queue. Ms. Imhoff, why don't you go ahead and take 2 minutes for us?
Despite the logo, it's Ms. Imhoff and Mr. Imhoff at the same time. So the only public comment we wanted to make was a disclaimer, a disclosure that Idaho law speaks to the fact that it's a one-party permission recording state, and federal law says that on the federal level it is a one-party recording nation. However, both laws speak to third parties who are not active or invited to actual conversations. As such, there is an active investigation in Ada County Sheriff's Office against Mr. Losby for publishing recordings under the assumption that he had at least one party permissive. However, he's identified as a third party according to Idaho state law, and there's an active investigation there. Further, on June 17th, he uploaded it to Google Drive servers, which are hosted both in Oregon State and the state of South Carolina. And we know it's been downloaded by people in California and the state of Colorado. As such, the Federal Bureau of Investigation Satellite Office in Salt Lake City has been contacted, and they have an open investigation, and we're currently waiting for them to assign us a special agent. So there are 2 active criminal investigations in regards to that recording. Anybody here that wants to use that recording, discuss that recording, or make any further comments about it, just be aware that I gave you that information. You can believe it, not believe it, you can care about it, you can not care about it, but it's recorded here that is a thing, and that's all.
Thank you, Mr. Imhoff. We will go next to Mr. Jonathan Jacobs.
Madam Chair, I have been asked to speak on behalf of the Sorensen group, I guess would be the best way to describe it, on relating to what exactly happened and to some of my observations on that. I don't know if it would be appropriate to start. I can if it would be, and if I do have the permission of this body to speak in this particular matter.
Madam Chair,
Yes.
after roll call, I would intend to make a motion for either side to allow whomever they wish to speak on their behalf, be that Mr. Jacobs. I'm not sure if perhaps the Imhoffs, the Imhoff group and Sorensen group, I think are the best way to refer to them, if perhaps they're going to have people. So I do fully intend after we take roll for me to make a motion that it's really the privilege of the two different groups to have whomever they wish answer questions and speak on their behalf.
Oh, that's totally fine. During public comment, we're limiting it to 2 minutes. So I don't expect Mr. Jacobs to just take 2 minutes, but I do anticipate giving everybody as much time as they need to present their arguments and for us to ask them questions.
Madam Chair,
Yes.
just in addition, I wanted to be clear that I would not necessarily be speaking exclusively for
Got
the
it.
group.
Okay, thank you so much. Okay, any further public comment before we get started? If there's none, going once, going twice, we may reopen it at the end if there are a lot of hands up or if conversation is just really going pretty hard. Let's go ahead and move to roll call. Madam Secretary, do you mind doing roll call for us?
I will do that in just 1 second. I've been informed, just so everyone knows, that I had the titles backwards on the Judicial Committee decisions. The one that said it was the decision affirming jurisdiction was actually the one on expulsion. So I was just busily renaming them so they are named properly now. Okay, and let me do roll call. The chair, Ms. McCardle, is here. Mr. Smith. Did you see Mr. Smith here, Madam Chair?
I did not. I will
Okay.
remind him right now.
Okay, and I will come back to that. Mr. Hagopian,
Here.
I am here. Mr. Blankenship,
I am here.
Mr. Bowen,
Here.
Mr. Elliott,
Here.
Mr. Nikala,
Here.
Mr. Rufo,
Here.
Mr. Benner. I will come back to Mr. Benner. Mr. Duque,
Present.
thank you. Mr. Eklund,
Present.
excuse me. Whew, Ms. Eiler. I see her. I didn't hear her, but I got you down, Ms. Eiler. Mr.
I
Ford.
am here.
And
Okay.
okay, gotcha. Mr. Ford,
Here.
Ms. Gabbard,
Here.
Mr. Nana.
Here.
Mr. Watkins.
God, peace.
Yeehaw. Mr. Clark. Okay, I'll come back to Mr. Clark. Mr. Cohen,
Cowan is here.
oh, excuse me. Mr. Dassing. I'll come back to David. Mr. Hall. Okay, I see you, Mr. Hall. Mr. Nepomuceno. I see
Present.
you. Mr. Pankey,
Here.
Mr. Tunyevich. Okay, and I see Mr. David Dassing is here. Is Mr. Tunjevich here? Okay, I'll come back. Ms. Yanuskevich? Okay, let me go back to the ones I passed over. Mr. Smith? And Mr. Benner?
Cowan speaking here. I know Dave's trying to get online, but he hasn't succeeded.
Okay. All right, thank you so much. So, Madam Chair, this is who I show as absent: Mr. Smith, Mr. Benner, Mr. Clark, Mr. Tunjevich, and Ms. Yanuskevich. In the absence of Mr. Benner, Mr. Cowan would be sitting in as Region 2.
So we have how many primary absences? Mr. Smith?
Mr. Smith and, well, Mr. Smith is the only one that would count towards against quorum that's absent. With Mr. Benner's absence, Mr. Cowan is serving in his place.
Got it. Okay, thank you very much. Okay, so I think the next thing that would be in order would be to hear from members of the Libertarian Party of Idaho. Actually, why don't we hear the motion for the notice of special meeting? Was there anything said formally?
No, Madam Chair, it
No.
was basically just to hear the issues surrounding the controversy between the two competing, the Sorensen group and the Imhoff
Right.
group.
Okay, there was nothing. Okay. So why don't we start with the members who requested the hearing, and then we should switch to the Imhoffs and or anyone else speaking with them or on their behalf.
And Madam Chair, would there, I'm sorry if I'm being a bit unclear. I would like, actually, I don't even know what I'm trying to say here. I
Right.
guess what I'm trying to say is, how are we going to handle questions and answers type thing? Are we giving people like, hey, 10 minutes for the Sorensen side to like just lay out what they would like to say, and then 10 minutes to the Imhoff side, and then questions and answers? I'm just trying to get a grasp on how this is going to go.
Mr. Nana, did you have a question?
I just had an opinion on how we could do that. Each side should theoretically get the same amount of time, to be fair.
Well,
That was-
definitely. Yeah. So why don't we start with 10 minutes? And then let's hear from both sides, 10 minutes each, and then let's open it up to questions. Is that all right with everyone? Is that okay? I'm not seeing any
Yes.
screaming or objection. Okay, great. Okay, so let's do that. Do we have Mr. Sorensen on the call? I see we have Jonathan Jacobs.
Yes, Madam Chair, I'm here.
Okay, great. So you and JJ have 10 minutes to begin with. We're certainly going to give more time when we ask questions, but however you want to sort that out. And then can I have an LNC member please be our timekeeper?
Okay, I just have a
Cowan
short,
will do that.
oh, sorry.
Thank you.
Okay, I just have a short little statement, and then I think JJ can better relate the rest of it. So I would just like to lay out kind of a timeline of events for anyone that's still unsure. I know it can be quite confusing. So I think we should start on April 2nd. The Libertarian Party of Idaho met in Idaho Falls to hold a convention. On May 17th, the state of Idaho held its primary elections. Several members of the Libertarian Party of Idaho were on the ballot as candidates for precinct committeemen. Todd Corsetti was the only member to reach the 5-vote threshold required by state law to become a precinct committeeman. On the night of May 30th, Mrs. Imhoff, Jennifer Luoma, the elected party chair and Region 1 chair of the executive board, as it had existed prior to the April 2nd convention, along with Mr. Evans, Mrs. Clark, and Mr. Imhoff, who had been named assistant treasurer in early 2022, signed a letter to the Idaho Secretary of State with the subject line, Notice of Reversion to the Original Executive Board. Mr. Imhoff claimed the title of acting treasurer on that document, despite being informed numerous times he could not own that or hold that office. Aaron Mason, Dan Carlin, and Kathy Smith did not sign the document. On the evening of May 31st, an email was sent to the LPID membership distribution list describing these actions and alleging the need for a new convention in 2022. This set of action has been described by the Imhoffs as the rollback, and the group alleged to be officers acting in this effort as the rollback board. On June 1st, Mr. Losby sent an email to the personal email addresses of the members of the executive board, withdrawing the claim of having formed the Ada County Central Committee. This email cited Idaho Code as the reason for the retraction. This statute specifies in part, provided that to be elected, a precinct committeeman shall receive a minimum of 5 votes. The email further made reference to other members of the LPID who may have made the same mistake and recommend reaching out to those individuals in order to come to a resolution with each. Mr. Collier replied to that email, also recognizing a similar error in his attempt to form the Canyon County Central Committee. On June 6th, an email was sent to the LPID membership soliciting members to volunteer to become precinct committeemen. This email did not describe the process by which such volunteers might take office, but alleged that doing so was necessary in order to fill out the state central committee. On June 16th, the law firm Echo Hawk and Olson, acting on behalf of Todd Corsetti, sent a notice of meeting of the state central committee via document service to Robert and Jennifer Imhoff at their place of residence. This notice was received that same day. The meeting was scheduled for June 20th. The notice indicated that that disciplinary action could be taken against Mr. and Mrs. Imhoff as a result of the meeting. They did not attend. At the June 20th meeting, the State Central Committee, 7 motions were made and passed unanimously. The State Central Committee adopted a resolution affirming that the April 2nd, 2022 convention was legitimate, proper, and having effect. Robert and Jennifer were suspended insofar as they claimed to hold the position of acting treasurer and chair, respectively, from those positions. Robert was suspended from the position of chair of the LPID, and I was appointed in his place, contingent on my resignation from the Judicial Committee. The Judicial Committee was tasked by the State Central Committee with considering this petition to expel Mr. and Mrs. Imhoff from the Libertarian Party of Idaho. The Executive Board was tasked by the State Central Committee to arrange the details of the next state convention. At the June 30th meeting of the State Central Committee, the committee resolved that mediation would be acceptable to reach a resolution if Mr. and Mrs. Imhoff agreed to it. To date, since the June 20th meeting, neither Robert nor Jennifer has contacted either myself or Mr. Belknap in order to transfer party assets to the officers, nor has either filed an appeal to their suspension with the Judicial Committee. On July 25th, minutes before the Judicial Committee's hearing regarding the matter, an email was sent from the LPID email exchange to the membership list purporting to announce a convention on August 27th, 2022. This email repeats the same claims that were first made in the email distributed to membership on May 31st and proposes an agenda consisting of public comment and election of party officers. On August 1st, the Judicial Committee rendered opinion on the expulsion of Mr. and Mrs. Imhoff. The decision explored all actions taken by the Imhoffs. The JC found that the Imhoffs acted to fundamentally change the very foundation of the Libertarian Party of Idaho. Quote, the events which have precipitated this position have had a serious negative impact on the party. Members are confused, officers disagree on who holds what position, and the cultural divide in the National Libertarian Party and its state's affiliate has become a structural divide in the Libertarian Party of Idaho. Members and officers are walking away in frustration, and the status of the party's asset is unknown to several elected members, including the treasurer. This situation is untenable and recalls echoes of the situation in Oregon, which is only recent resolved, as well as recent events in New Hampshire, Massachusetts, Delaware, and Pennsylvania. Mr. and Mrs. Imhoff were asked in the interview to cite the sections of the bylaws on which they relied when they decided to execute the rollback. They did not offer a citation at that time, nor did they offer any written citation between the time of the interview and the hearing.
About 2 minutes left, Jason.
Okay, well, shortly after the ruling, the Sorensen board sought out an opinion of a registered parliamentarian and also to further investigate the issue, and I'll leave him the last 2 minutes.
Madam Chair, before Mr. Jacobs speak, I'm wondering if there would be objection to give, because I do not think we're going to be able to hear from a parliamentarian in a couple of minutes, to give both sides 15 minutes instead of 10. I want to keep it as equal time, but I also don't want Mr. Jacobs to feel like he has to talk in 2 minutes.
I'm fine with that. I don't want to prejudice the Imhoffs. It's basically waiting another 5 minutes, but we'll certainly give them the same amount of time, and anything more than that we'll address in questions, if that's okay. Okay.
Madam Chair?
Yeah.
If I may, I was tasked with taking a look at this particular issue, and had been mentioned informally to take a look at the situation in the, I believe it was Bannock County Committee, to determine if Mr. Corsetti was in fact duly elected, and that he was duly elected ultimately to the State Central Committee. My determination here basically started from the premise, since I am not an attorney, that the opinion of an attorney licensed in the state of Idaho was wrong, and that the Imhoffs had a legitimate claim. That might sound a little bit backwards, but I think it will work out quite well in the explanation. My determination was that if this claim is legitimate, they cannot do anything short of, except, or I shouldn't say short, they cannot do anything except to talk to the, except to go through the Judicial Committee or the State Central Committee. In other words, if there is a problem, it would have to be rectified through them. There is an opinion to that effect. Mr. Imhoff was the chair at that particular point. There was no determination by any meeting or by any group that he was not the chair. There was only a determination by somebody who used to be the chair, claiming to hold that position. Had this been a legitimate complaint, Mr. Imhoff could have gone to the Judicial Committee, or could have gone and requested an opinion. He could have done so. He would have had to have gone through either the Executive Committee or the Central Committee, or he could have gone directly to the Central Committee and said, I think there's a problem. We need to have a convention. We need to summon up people there so that I can make this ruling where it would be appealed. Now, none of those things happened. Just suddenly, out of the blue, there was a letter stating that, guess what? He's now, Ms. Imhoff is the chair. But there was no attempt there was no attempt here to actually put this before a meeting of anybody of the Idaho Libertarian Party. I will say that I was not aware that that there had been a complaint filed against against both of the Imhoffs relating to expulsion. I would note that opinion, however, did go to the State Judicial Committee, and that they did rule that the action that the convention taken on, or that the convention on April 2nd was legitimate And they also have, I should say, this would be Mr. Let me just refresh my notes because I'm getting older. Refresh my that Mr. Corsetti had gotten a legal opinion from an attorney who is licensed in that state and has submitted a legal opinion that the election was in fact valid and that the convention was in fact valid. But even if he was wrong, you would still have to go through a process to declare it void. It could not be declared void outside of a meeting for the reasons stated. I can move into the, if you would like, I can move into the composition of the state Central Committee. As noted, Mr. Corsetti was elected as a member of the, as a precinct committeeman in Bannock County. He was the sole person elected to that position. Under the bylaws, all members of this, even if it's just one member, can elect a county chairman, can elect a state committeeman and a state committee woman, and with anybody else elected in the legislative district, can elect a legislative district representative. That is what he did on, I believe, 2 successive nights. He gave notice effectively to himself. There were no absentees. And he elected himself and I believe his spouse to the positions of county chairman and state committeeman, state committee woman, respectively. Mr. Imhoff had a duty as chair, as he was at that time, to call a meeting of all the committeemen in that county, all the committeemen being just one person. He had 10 days to do so, and he did not properly call that person. After that, I believe that operating under Robert, the first named person on that committee, again, Mr. Corsetti, had the authority to, after notifying all the members, call that meeting and properly conduct that meeting, which is what he did. Therefore, I believe he was properly elected to this board. I would note, since I love to do this, that there is precedent for this going back to at least 1830, the election in Bootshire for Parliament, and that I, in fact, mentioned the concept of a one-person assembly very similar to this in a paper called Basic Assembly Characteristics in 1999.
About 30 seconds.
And that finally, we do see something like this happen with the concept of designated survivors in the US Congress, where they will have somebody sitting aside just in case something happens, where one person can elect somebody. I think that's it. Thank you.
Okay, thank you very much, JJ. That was about 15 minutes. So at this point, let's turn it over to the Imhoffs and anyone that they would like to share their speaking time with.
Thank you. This is Jennifer Imhoff speaking. To start off, go down our timeline of what we think is important. On May 28th, 5 members of the party, including the vice chair-elect and 2 members of the judicial committee-elect, submitted minutes for meetings declaring themselves as county and or legislative chair districts, along with several non-members being appointed to state central committee. In order to acknowledge the precinct committeemen elected during the May 17th primary as part of our state central committee, a rollback was in order to allow all dues-paying members the opportunity to understand that the structural changes and to participate in county organizations at the same level that non-members were allowed to. On May 30th, all of the members of the 2020 Executive Board and a majority of the April 2nd board voted to roll back the Idaho Executive Board to be all the members of the 2020 board, with the exception of the treasurer, who had officially resigned on April 2nd for personal reasons. On May 31st, the Assistant Treasurer delivered digitally signed documents to the Idaho Secretary of State's office to signify that the current structure of the membership of the Libertarian Party's Executive Board. They marked the document as received and gave us a photocopy for our records. The Rollback Board had an informal meeting call later that day to reaffirm that they would be the temporary Executive Board until such a time that a new convention could be held, and all made verbal commitments to constrain the activity of the board to investigating the actions that caused the rollback by a minority of members and to ensure that a convention would be held in a timely manner. An email went out to the State Central Committee members, which are also referenced as bylaw sustaining members, that a rollback had occurred, why it occurred, and to stand by for more information for an upcoming convention to correct those issues. All actions of the Rollback Board were prompted by the documents sent to the board on May 28th. There has obviously been a lot of talk about an alternate board in the state of Idaho, and we're here today because they have come to the LNC to assert that they're the true executive board of the party. Well, we've seen some social media chatter where they purport to be the board. We ourselves have not been informally contested by these actors. After this road board sent an legal document from law offices within Idaho to 2 members of the Rollback Board, we have been in contact with the Secretary of State within Idaho. The Deputy Director assures us that we are the current recognized legal entity representing the Libertarian Party of Idaho. As such, we continue to submit financial filings in accordance with the Idaho state law as the correct legal entity. We have been in constant contact with many of the State Central Committee members. While we found one who disagrees with our position, and obviously those involved in this road board, we have not formally received any protests, complaints, or concerns directly from any State Central Committee member to this date. We observed on social media that a judicial committee had formed to take specific actions against 2 Central Committee members. However, that judicial committee was activated by a road board. That road board is not recognized by either a majority of the State Central Committee members or the state of Idaho itself. The 2 members in question, at the request of a well-respected Central Committee member, Mr. Ratty, agreed to discuss the judicial committee matter with him to clarify that the road board does not have the authority, and thus the so-called judicial committee is also invalid. They only agreed to talk to Mr. Ratty out of respect for him and not to recognize that judicial committee. Mr. Ratty agreed that the calling of the judicial committee was not in compliance. This current board is pleased to inform you that we will have an election on August 27th, and we will be hosting a hybrid convention both in person in Ada County and online via Zoom for all qualified State Central Committee members to hold that convention with an explicit purpose of electing an executive board. We have already seen many Central Committee members begin RSVPing, along with many members who have begun social media campaigns eager to run for various open offices. We're asking the LNC to recognize that the current executive board is taking the appropriate actions to remedy all party concerns. If after the August 27th convention, the LNC is unhappy with the outcome, we hope that you'll reach out to whomever that board is to reconcile any concerns you have. With that, I'll yield my time.
Okay, thank you very much. I see Dustin Nana's hand is up. I imagine there are going to be other LNC members who have questions. So if you're going to have questions for either side, please go ahead and get your hands up so that I can start calling on you. Okay, I have a bunch of questions as well. Let's go to Dustin Nana first.
All right, thank you. Can everybody hear me okay? Good. All right, so I have a couple of questions. One thing I noted during Ms. Imhoff's testimony, you said that the current Idaho Secretary of State recognizes the board that I guess would be your faction. Do you have any documents to support that claim?
Sorry, what was the question there?
Do you have any documents to support the claim that the current Idaho Secretary of State recognizes your side of the dispute?
We have documentation where they acknowledge the rolled backboard as the board. That's official letters addressed to the chair, which would list me.
Okay, and then follow-up question. It appears to me, at least, that the April 2nd convention was legitimate. This is a question for the other side of the dispute. Do you think that the April 2nd convention was not legitimate, or that it was legitimate?
Who's that question for?
The non-Imhoff faction.
Sorensen? Okay,
Yes, the Sorensen faction.
Madam Chairman, if I may answer.
sure.
In my opinion, the question is a legal question and could not be answered by anybody who is not an attorney.
Okay, I want to
hinges on-
hear you say that, but I definitely want to hear from Jason too.
Okay. It hinges on if they complied with the law in calling that convention. That would be Ms. Imhoff who did so. The second point would be that I would give is that under the bylaws, the Judicial Committee may interpret the bylaws. In fact, they appear to have absolute authority to do so. And that they unanimously, including Mr. Ratty, made the determination that the convention was properly called, properly held, and that these were the people that had been on the board for the reasons that they have stated in their opinion. So based on those two things, I would say that it would be a legitimate meeting.
I concur. I saw the attorney's opinion, and it seems to be legitimate, at least in my mind. And then, so one last question.
Wait, let's hear from, I want to hear from Jason Sorensen too.
Okay.
If that's all right.
That's
Yeah, we 100% believe that the April 2nd convention, it's been looked over by an attorney. It was gone through by the JC. They all believe that it was in order.
Okay, thanks.
Okay.
Sorry, go ahead, Dustin.
You're fine. My final question was about the August 27th convention, and this is for both sides. Do you believe that the August 27th convention is legitimately called?
Let's hear from the Imhoffs first.
Yes, that one was legitimate and called.
And from Jason Sorensen and JJ?
If I can go, no, I do not believe it was legitimately called. This has to go through the State Central Committee. And the State Central Committee at this point consists of just Mr. Corsetti and Mrs. Corsetti. They would have to go through that method to call according to the bylaws. I think that certainly Mr. Imhoff could have used that method, but he did not do so. So my opinion is that it would not be a valid election or a valid convention, and that the actions would be null and void from that action.
Got it.
If I may add, also on the Sorensen side, we also do not have any stipulation in our bylaws whatsoever for calling a special convention of any kind. The only type of convention which can be called is the regular convention, unless a regular convention suspends the rules in order to allow for a special convention. This happened in 2021. There was a bylaws amending convention that was moved for the 2020 convention. And according to Robert's Rules of Order, if there is not provision for a special convention in the organization's bylaws, none can be called except by a regular convention. On top of that, the purported notice, which was sent out to the mailing list, says that an RSVP is required in order to receive the time and location of the convention. This is also a violation of Robert's Rules of Order because the notice of the convention must include the time and place. We have also been in contact with someone who has RSVP'd in order to find out, and that RSVP was responded to with an automated message that had the time and said that the location is to be determined. So in many different ways, this is not a valid call to convention.
Okay, thank
If I
you.
may clarify, this is not a special election. This is a convention. We're redoing the convention. And while we did not provide those details to Chris Ward's wife, we do intend to as soon as those details are available. Once they're available, they will be posted everywhere. We just don't have that link at this moment.
Okay.
Madam President, may I, or Madam Chair, may I speak briefly?
Okay. Yes, and then we're gonna move on because I have some questions myself. Go right
Just
ahead.
on a clarification point, I believe that that a convention could be called under state law at some time different than the bylaws. That might end up effectively being a special convention, but it would be one called under the provisions of state law outside of the bylaws.
Okay, thank you very much. Okay, so I have a couple of questions that I wrote down, hearing from you all. I'm just going to run through them quickly and then we're going to move down the list. For the Imhoffs, can you state again, I'm sorry if I missed it, who decided that the initial convention was not valid or void?
That was with the entirety of the 2020 board and a majority of the April 2nd board.
Okay, do you have a vote or a list of the people? You said it was the entirety of the 2020 board, and then for the 2022nd board, does that mean the April 2nd convention people?
Yes.
Okay, so which April 2nd executive
would've
committee
been-
members?
Included Robert Imhoff, myself, Beth Clark,
Mhm.
and Dan Carlin at the time agreed.
Okay, got it. So that's 1, 2, 3, 4. Great, thank you so much. And then let me see, the next question I had was, who was in communication with the Secretary of State for that letter? I believe there was a letter sent to them.
Yes, so that would have involved, all of us were involved in the letter. It was delivered by Robert Imhoff and Joe Evans. Following meetings also included myself, Robert Imhoff and Joe Evans.
Okay, so Robert Imhoff, Joe Evans, Jennifer Imhoff, and then anyone else?
No, not for in-person meetings.
Got it. And then you said you'd been in contact with the Secretary of State. You said that they'd recognized you because a letter was addressed to you. Was there any other type of recognition that they provided you?
The campaign finance portal recognizes us. Their internal files all have us named. And again, any communications going out to the chair of parties are addressed to me at this time.
Okay, so they all recognize you specifically. Have they made any comments about determination of who's the rightful leader, chair, board,
No,
anything to that effect?
that's
Okay,
for us to determine and go through a process.
got it. Okay, thank you very much. So I'm gonna stop with my questions there, and then I'm gonna go down the list. Thank you, everyone, for being patient. Next up is Ms. Karen Ann Harlos.
Okay, I had to unmute, and I'm probably going to be in line several times because I don't want to do everything at once. And it's not all questions. There's actually, I think, some statements I'd like to start with. Though I think this has been acknowledged, there is something I found a bit distressing that was in the opening statements and also in the documents of a refrain that a kind of invoking the imprimatur of the state as saying, well, the state has recognized such and such. I know from experience with secretaries of state that they do not involve themselves in the internal issues. What's been represented as the state recognizing is not a recognizing of legitimacy. It's merely an acknowledgement of filings. So if you ask the Secretary of State who the chair of a party is, they're gonna tell you who's on the filings. They're not rendering an opinion that they think it was done properly. So I'm a bit concerned by that, but I think that's been clarified now that the Secretary of State of Idaho has received filings and they've basically parroted the filings back. They have not rendered an opinion on this. They don't do that. They just don't do that. But there's something I put on the list that I want to have on the record for this meeting, because I do think we can get down a lot of rabbit trails. There's a lot of sub issues going on here, but the only thing that we have any authority at all to be concerned with is we have two boards of directors that are competing boards of directors. It's very similar to Delaware and Massachusetts. I know there's issues with, the validity of expulsions, and I'm very vocal on the record that I detest expulsions, even if they're done right or wrong. That's not in our purview. There's one issue here that is of utmost importance. It might have sub issues under it, but the issue for us here is whether or not the April 2nd, 2022 convention was valid. If that convention was valid, it seems pretty clear to me then that the Imhoff group is incorrect and that the Sorensen group would represent our Idaho affiliate. However, the converse is not true, because even if the April 2nd convention was invalid, there's been no real formal valid. It wasn't validly declared invalid, even if it turns out to be invalid, if that makes sense. From what I understand, the 2020 board decided it was invalid, but conventions are presumptively valid. The 2020 board was out of office. They had no authority to even be considering this. It would be the 2022 board that would say, hey, our elections weren't valid. You can't have the people that were voted out of office then say, well, we actually weren't voted out of office. That's just not the way things work. So if there was no valid means of declaring it invalid, we still have other issues. Now that would have to be resolved internally by the Idaho party, but I don't see any means here of a clear path, even if the convention was invalid, to say that the Imhoff group is correct. I see we have two issues here. If the convention was invalid, then the Sorensen group is correct. They might have some issues that they still need to deal with internally. If the convention was invalid, it needs to go back to Idaho to go through a valid process of declaring it invalid. I know that seems quite circular, but there's a lot going on here. I think the only question before us now is who is the chair / legitimate board of our affiliate. And if we can't determine that, like the facts are just too unclear, or we think both groups are incurably wrong, we are only left with two choices. So actually we have three here, the ones I already laid out, but if those are impossible, we could just say, you know what, leave the two competing boards alone, hoping that they'll come together. But in the meantime, we would have an affiliate in Idaho in name only, because members, I've seen this go on in Oregon, members wouldn't know what board to join. No presidential candidate's going to want to get involved in that, not knowing if they're going to be on the ballot or if they're going to have the endorsement or who the actual affiliate is. Do they go to two different conventions? Or there's always the nuclear option of disaffiliation. I just want to put out here what our actual options are. Now I actually do have some questions. 1 second here. I think some of them may have been answered. This is to JJ, though he might not be able to answer. What state law is it that you believe would allow a special convention to be called outside the bylaws, particularly one that would elect officers? Because it seems the bylaws to me are pretty clear that there's only regular conventions and they have to be within a certain time period in April.
Ms. Harlos, first of all, the bylaws permit meetings to be called under two circumstances. First, it is in the last 2 weeks of April of each year and in accordance with state law. Both sides here have claimed that under state law, the Central Committee can call a meeting. The case that was cited, and I don't want to actually cite the particular statute. I believe that was put in the letter. I could look it up, but that there would be a general provision in state law that says that a meeting could be called at any point by the state executive committee.
Okay, I have the statutes here. I understand your argument now. Hold on, I'm gonna, I can find that. All right, that's all I'm gonna have for right now. I want to let other people talk. I don't want to monopolize, but I will put my hand back up to get to the end of the line.
Madam Chair, like,
Yes.
I feel like it's only fair, especially since our side has yielded 4.5 minutes, that we also, our side, be allowed to retort or
Oh, yeah.
She made a lot of statements there.
By all means, JJ, why don't you finish your thought and then let's go ahead and hear from the Imhoff so they can give a rebuttal.
My only question here is, or my only comment here is that it is the section that was posted is 34-707. It is posted in chat. And that seems to be the one that everybody is relying on.
Okay. Thank you very much. Let's go ahead and give the Imhoffs a few moments to respond.
So, yeah, I want to make a bold statement here because it seems like there's already some misalignment of understandings of what has occurred here. To be clear, since we're going by Sorensen and Imhoff here, both the Sorensen Executive Board and the Imhoff Executive Board, they both agree that the April 2nd convention was not wholly valid. We know this because the meeting minutes from the June meeting, State Central Committee meeting that they provided make that assertion. If magically there's only 2 State Central Committee meeting members that exist that could hold a State Central Committee meeting, then, and they're having a State Central Committee convention at that time, and then they say, well, that happened over there, but we'll make a motion today to just say, everybody on that board, we'll just call them the board moving forward. I mean, that's what their meeting minutes say. So by their own meeting minutes, they're saying, we 2 people wholly control State Central Committee acts, one of which is calling conventions to elect a board, but we're not going to call a convention to elect a board. We're just going to simply say those people in that invalid meeting over there, we'll just now make it valid because we can do so as the 2 sole State Central Committee members. So those minutes themselves affirm neither side agrees that the April 2nd meeting should have happened. The second important point is that the bylaws say that it should be done at the last 2 weeks of April. April 2nd is not the last 2 weeks of April. Only after all the elections occurred, and it occurred in such a manner which was amicable to a minority of members in that convention, did they make a motion to suspend a rule where they said, we shouldn't be here right now, we were supposed to do this in 3 weeks from now, but can we suspend the rule to accept all of these election results after the elections? It's quite, we saw at the national convention, people first suspended the rule before the convention went underway. In this case, an entire convention occurred, and then seeing results that are satisfactory to these people, only then did they make a motion to suspend the rule to validate them. What would have happened if people were elected to the board at this meeting and it was not satisfactory to their outcome? They would have made a motion to say, we all shouldn't be here. So, I mean, these are two very core facts into who's right and who's wrong. There could be an argument made that nobody's correct here, but who is less not correct probably is a better way of approaching this, especially since we have an avenue out in 2 weeks. And then the final thing that I'll mention here, because I know I've been droning on, is that how are these two state central committee people, how are they valid? It says very clearly in the state law that you must have precinct men, but you also must follow whatever your bylaws say. So anybody that's read the Idaho bylaws, it clearly states in there, if you want to have a county convention and you don't have a county chair, which Bannock County did not have, you must reach out to all bylaws sustaining members and give them 2 weeks notice that you wish to have an election. It says it very clearly in the bylaws. So if the state rules say, do this plus whatever your bylaws say, then you have to look into our bylaws and see what it says there.
Okay, so thank you very much, Mr. Imhoff. I'm gonna make a request. We did hear, from my understanding, from JJ and Jason Sorensen, that they believe the April 2nd convention was correct. So I'm going to ask both sides going forward to try not to speak too much on behalf of the other party. I'm going to go ahead and let Matt Losby respond, but please keep it really brief because we're going to go down a list of questions and there are going to be more LNC members who have a question, but go ahead, Mr. Losby.
Okay, yeah, I'll try to be brief regarding the motion at the end of the convention. The motion was not to suspend the rules. The motion was that all the delegates at the convention would recognize it as a legitimate convention despite the incorrect date. Regarding the appointment or creation of a county central committee, nothing in the bylaws requires 2 weeks notice. The only mention of it is, I'm attempting to find it right now, but I have it pretty close to memorized. Okay, if a county central committee does not exist, the precinct committeemen within that county shall form one based on state law to the maximum extent practical. There's a following section that says, in the event there are no duly elected precinct committeemen within that county, then the dues paying members of the party residing in that county shall select precinct committeemen for the purpose of this and the following section. Since there was a duly elected precinct committeeman in Bannock County at the time, this part is not relevant and nowhere does it mention 2 weeks.
Okay, thank you very much. Okay, so we're going to jump down to Martin Cowan. Before we do real quick, Ms. Harlos, at what point did you jump in to line again? Because your hand, I forgot to lower it. I apologize.
I don't know.
She lowered it and she jumped back in.
I think Mr. Evans and or Mr. Nana was on deck. I just want to make sure I call on you in the right order.
I know I'm not going to be popular for saying this, but Madam Chair, I object to non-LNC members being in line until LNC members have had the chance to ask questions. Idaho members certainly can be designated by either the Sorensens or the Imhoffs to respond to questions, but this is now an LNC meeting, so I would object to having in line to speak on their own, not answering a question, non-LNC members.
I think that's fine. I will recognize, I recognize your objection. I would ask someone to call on Mr. Evans at some point briefly, an LNC member, so he can get his opinion. And yeah, let's handle it that way. And Dustin, I am so sorry. I think as I scrolled through this, I accidentally lowered your hand. That was not intentional. But okay, so let's jump to Mr. Cowan. I'm sorry. Mr. Cowan, go ahead and ask your questions.
So perhaps I should know the answer to this question, but I would love for Party A to state their ask of us, and I would love for Party B to state their ask of us. I mean, what are they asking us to do? That's the first thing. The
Let's
second
call
thing is,
them the Sorensen board and the Imhoff board.
as you say. The other thing is that, you know, a convention in 3 weeks would really solve the LNC's problem, because then we wouldn't have to intervene or fool with it, because in 3 weeks it'll be resolved. And I understand that some people object, or the sides are not in agreement that that's a good convention, but I'm asking the sides, why can't the sides agree on some date, which is a good convention, and have the membership decide this for them and for us? I mean, I really have the membership decide this rather than me and this board. That's the end of my speech.
Okay, thank you very much. Let's go to Mr. Pantke.
Thank you. Well, first I thought that Mr. Callan had requested a response from both boards, right? As to what their ask of us was.
Yeah, that was my first thing.
So would each board like to state what their ask is?
Let's do that. Sorensen board, would you like to make a statement?
Yeah, I think our ask is pretty simple. We're just asking you basically to decide who's the legitimate chair and subsequently the legitimate board. And that really solves the issue. Did you want me to answer his other part, or?
Sure.
Well,
Yeah.
the problem with having another convention is conventions cost money. So we don't have a lot of money. And so to just say, well, all these people that traveled from northern Idaho or wherever, which is a 9 to 10 hour drive, to say, oh, sorry, you don't matter, and sorry you wasted the money, is a pretty big ask. And, you know, if that was me, I only had to drive an hour, but I'd be pretty upset to just then, why did I waste all that money to drive to the convention?
Okay, let's go ahead and hear from the Imhoffs.
Thank you. Our ask is just that. Let us hold the convention, because this decision does belong to the members. To be noted, we have always included everyone, including Jason Sorensen and all his board contingent, in every communication, in every invite, and every opportunity. There's been no efforts to tinker with membership status, with delegate status. We're welcoming them to run for those same seats, just as everybody on our side. In fact, we have a couple of outsiders who are willing to take over, because they are questioning, you know, the stability, and they want to see resolve. And so, you know, our ask is, yeah, just let this play out. Now, to address Sorensen's concern, we're not asking for any money from any members. This is being done out of personal pocket to make sure that there is not a financial burden on anyone. And also why we're going through the process to make sure it is a hybrid event, so no one needs to travel.
Okay, let's go on. I feel like this is going to come up again, but let's continue to go down the list. Let's go to.
Madam Chair, can I continue with my line now?
Oh, yes,
I
absolutely.
want, yes, thank you.
Point of order, Madam Chair. Sorry to interrupt, but sorry, we kind of muted too quick there. We had one more statement, if we may.
Sure, absolutely. Go ahead.
We have said what our ask was, which was to just kind of close down this meeting, and maybe we can just reconvene after the convention with National. The other side said they explicitly want you to recognize them. Now, the Secretary of National has already stated moments ago, we are not here today to do that. So if one side's ask is for you to do something today to recognize something, when your secretary has already motioned that you probably don't have that.
Oh, no,
And we're asking for a convention.
No,
I'm so
Sorry,
sorry.
I'm sorry. I'm sorry
Please
for
do
putting
not
words in
put
your mouth.
words of-
If,
thank
No, that's
well,
not. And that's
let me
not.
finish. Let me finish.
Actually, no.
I
Actually,
apologize.
no, Mr. Imhoff, because that's not what Mr. Sorensen said. To my understanding, I don't recall him asking for us to do that today.
Didn't he just say why he's here today?
But there's no noticed motion for today. This is only investigatory.
I understand. But I'm just merely making a statement that if he's saying that that's his ask, what are we doing today?
We're continuing our investigation.
Okay, thank you.
All right. Thank you, Madam Chair. I hope I'm clearer now. I would like to preface my line of questioning with a couple of facts. That way we can color the nature of why I'm asking the questions that I'm asking. And I first would like to say that I hate being in the position of having to ask these questions. But the first thing that I would like to say is that with regards to Idaho state law, I don't think that the LNC and I believe the parliamentarians would agree, can make any positive ruling as to what part of Idaho state law controls, or how specifically whether or not something is valid according to Idaho state law. And that question ultimately would have to be answered by a court of competent jurisdiction. That's really the only entity that could rule on that. I appreciate that we have attorneys that have weighed in on the legal issues at hand. The only action I would largely agree with our Secretary, Ms. Harlos, in saying that we can either recognize a board, do nothing, or disaffiliate as being our available options. So my line of questions purely concern on the only non-disaffiliation action that we have, because disaffiliation would be viewing the Party of Idaho in its totality versus something specific, which is also something that we have done in other cases that this board has voted on in the past, which is the appropriate board. Now, given that, it doesn't seem to me that as far as the legal issues are concerned, that either the April 2nd convention was valid or it's not. But if it's invalid as a matter of more of a matter of law, because the two controlling pieces of law that we've written to and Mr. Jacobs has spoken to is either the state central committee can call the convention at a time of its choosing, which is where both in the evidence that I've seen, where both the attorney and Mr. Jacobs have relied on saying, hey, that this is a valid convention, or it's not, that would be rendered by a court of competent jurisdiction. And at that point, it would be the court of competent jurisdiction ruling that we would have to go and deal with. So I'm left in a position of asking, okay, if the convention is valid, then what has transpired following from this, which is also very confusing, happened, because my default area as to who's the chair is the chair that was recognized during the convention, which is not the board that either side has declared that they believe the composition of the board to be. And I rely on that by going and looking at the Central Committee member minutes, which is the only other area in which the composition of the executive board was changed from what was declared at the convention. And in those meeting notes, I would first like to note, ask Mr. Corsetti a question, if he would be able to answer, and ask whether or not the meeting minute that was called by the Central Committee, whether or not you called that and who you believe to be the voting members of that meeting were. If you could speak to that, please.
Sure. So I was elected, so I am the SCC along with my my wife. So we had, can you ask that question again, please?
Sure. I would say is that the meeting minutes that I have in front of me have in the notes, have you as being the person, well, first of all, that you being the person as you and your wife as being the only state central committee members coming out of 2022's primaries, and the resulting, committee meetings, that you did call the central state central committee meeting, and that in my notes it says that you were the only voting members in that meeting. Is that how you understand that?
Yes.
That
Yes. Okay. Thank you. So the statutes are pretty clear on who makes up the SCC. We held that meeting. It's pretty clear, and it's been verified by the attorney that I got an opinion and JJ, who is in the SCC. There's nothing in the statutes or in the bylaws that allows the Imhoffs to start stacking the SCC. So there's 2 voting members of the SCC. It does state that, and this was verified by JJ and the attorney, who is also a parliamentarian, that the executive board is the executive board of SCC, but non-voting members. So just to sum it up, there's 2 voting members of the SCC.
Okay.
So answer all.
So if that's the logic that is used, it is my understanding that prior to the convention and prior to these primaries, there were no voting members of the SCC, right? Because there had previously not been any members from 2020 to 2022 that would have been voting members of the committee.
There has never been an SCC in Idaho.
Okay, until now, until this SCC.
Until I was the first one elected as a PC that then proceeded. Yes.
Okay. Then my following question, I would like to ask Mr. Jacobs, since you're the most well briefed on this. If we're presuming that either the bylaws or the SCC can call it, if there are no voting members of the SCC, then how could we reach the conclusion that the SCC had the authority to call the convention on April 2nd?
Well, there are 2 matters there, which I alluded to.
Okay.
I will add a third one. The first one is that according to the opinion of the attorney, it was a valid election because the officers of that committee, of the state central committee, which did exist, and were the officers of the board and were the officers of the party as a whole, could call it. That was basically his opinion. The second thing was that I would base this on was that the group that has the authority to interpret the bylaws, rightly or wrongly, is the Judicial Committee, based on, if you will let me refer to this, a statute that says, or excuse me, a bylaw that says that that upon referral, the Executive Committee may adjudicate, quote, ambiguities or conflicts within and between the bylaws or other governing documents, procedures, or practices. That's Article 8, Section 5B. That would give them the authority to make the interpretation, even if that interpretation would be wrong. I would add a third point, which involves on what would almost be a legal fiction. The board members, the officers, the 4 officers of the board of the party are also the 4 officers of the board, including, of the central committee, including the chair. In theory, at a proper meeting, the chair could ask for unanimous consent and say, if there is no objection, we will hold the convention on April the 2nd. There were no people there who did object to it. It would require at that particular point, because there are no people, there are no other members of the committee. It would ultimately be left up to the chair in calling that action. As I said, I would regard that as almost a legal fiction where you are assuming that they are calling this without objection. They could hold the meeting, all the members were present. Nobody objected to this because there were no other members. So that would be a possible parliamentary explanation as well. I'm not thrilled about it, to be honest with you. I think that it has some implications that I don't like, but I also think that that would be a legitimate way to look at this. So under all three of those matters, I would say that that is legitimate.
Okay. And Mr. Jacobs, just as a follow-up on this, because this is where things get really stewy, and I wasn't expecting Mr. Corsetti's answer there was, so I'd just like you to address this directly, that the meeting, the State Central Committee meeting that was done that removed Mr. Imhoff as chair, which is the only other compositional change that I'm aware of in the minutes to the executive board, which is the area that would most concern the LNC. That meeting noted that there were only 2 voting members, both of which were the Corsettis, that had the, and I just want to make this clear because it gets into an area of, I would almost say a similar fiction, that those 2 people, if the rest of the officers are not allowed to participate in the voting and in the motions for the removal of the chair or other officers, that these 2 people could, by simple vote, call of the Central Committee vote, remove all of the officers of the executive board if they so chose, and replace them at their discretion, and could do so at this time, today, or any time going forward until the next regular convention.
I think that you.
Okay, after this, we got to move on to the next
Okay.
person.
Okay. If I can answer, I think that you've kind of overstated something a little bit here. The SCC does not have the authority to remove an officer. It can refer that, as the sole body that can refer that, to the Judicial Committee. So even if they are the complete officers there, and they're the only 2 people that can do this, they could not in and of themselves remove an officer. You would have to go through the Judicial Committee. In that regard, yeah, they could begin the process. These 2 people could begin the process, but they could not remove the person. It takes the Judicial Committee to remove that person.
If I may, a minor correction, the State Central Committee is capable of suspending, and then that suspension is appealable to the Judicial Committee. I will say that just as a member of the Judicial Committee, if the State Central Committee were to say we're suspending Jason Sorensen because his hat is red, I think we would convene pretty quickly and overrule that suspension.
Okay.
Thank you.
Okay, here's where we're going to go from now. We're going to go to Connor Nepo because he hasn't spoken yet. Then we're going to go to Linnea Gabbard because she hasn't spoken yet. And then we're going to go to Dustin Yan, and then we're going to go to Karen Ann Harlos.
Thank you, Madam Chair. I have a series of questions for the Imhoff board. So I think the fundamental matter here, and I think all other matters are tangential to this, is was the April 2nd convention legitimate or not? So my series of questionings will be pertaining to that. So I would like to start with who scheduled the convention on April 2nd?
That was scheduled by members of the executive board.
I don't have that information in front of me. Who were the members of that board previously?
That would have been myself, Beth Clark, Joe Evans, and Jennifer Luma, and Dan Carlin.
So was that convention knowingly scheduled in violation of the bylaws if they specify a certain time at the last 2 weeks of April?
Yes, because while the bylaws might have been in compliance it negated legal requirements. By holding the convention before the primaries were completed, we were not able to include precinctmen with that state central committee makeup. Hold on one second. Sorry, can you restate your question? I want to make sure I'm answering it correctly.
Did you knowingly schedule a convention in violation of what it says in your bylaws? That's what I asked.
No, not knowingly.
Okay. Moving on from that. A motion was made at the close of the April 2nd convention to recognize that convention as legitimate. And according to the minutes, it was passed with no objections. It's my understanding the members of the Imhoff board were present at the time. If they knew this convention was conducted in contravention to the bylaws and to apparently the law, why didn't you object at that time?
Because we did not know at the time. So at the time, we were under the assumption that this worked. It wasn't until meeting minutes came in with people declaring themselves precinctmen. And it was also Zach Collar, who was acting as vice chair at that time, who brought it to our attention in an executive meeting, said, hey, precinctmen need to be a part of this process. And that's where we all stopped and had to reevaluate what happened. That would have been May 24th.
Thank you. Next question then. So if you had determined that this April 2nd convention was illegitimate in its entirety, wouldn't the responsibility of correcting the matter fall into the judicial committee that was serving before April 2nd? Was that judicial? I'm sorry.
There was no judicial committee prior to that.
All right, so there wasn't a judicial committee to consult. So
to correct. That is correct.
So was the judicial committee created over the course of this convention, the April 2nd convention?
That is correct. The judicial committee was filled during the April 2nd convention. No member of the judicial committee sat prior to that, at least in the 2 years that I am aware of.
Understood. That covers my line of questioning. Thank you.
Okay, thank you. Let's jump over to Linnea Gabbard, and then we're going to go to Dustin Nana and then Ms. Karen Ann Harlows.
Pardon me, Madam Chair. Could I offer some information on that same topic before we go to the next questions?
Yeah, let's go briefly, but yes. Okay, yes, let's go briefly, but go ahead, please do.
Okay.
Okay, I'm sorry, Mr. Evans, you're not able to object.
All right. My understanding of the requirements of law, and I'm not a lawyer, this is a programmer reading law, so take it as you will, is that in order to call a convention, the state central committee is required to notify the county and legislative district central committees, like the central committee on which Mr. Corsetti sits, of the convention. And that's supposed to be, according to the law, how the convention gets noticed out. Our bylaws also add in that you need to notify all of the bylaws sustaining members. Because in February and March, there were no central committees other than the officers sort of sitting on the state central committee. When the previous board notified all of the bylaws sustaining members, they also successfully notified all of the county and legislative district central committees that existed, which is 0. And then,
sorry, that's because we didn't hold the election yet.
We're not going to do crosstalk. We're not going to do crosstalk.
And so we also in our bylaws require a convention every single year. We only have primary elections in Idaho every other year. So if it were necessary for a primary election to occur before the call to convention in a given year, our bylaws would not be able to be followed in calling those conventions. So that is what I had to say on that subject.
Okay. Thank you, Mr. Losby. Okay, we're going to go next to Ms. Leah Gabbard.
Sure. Okay, so Connor actually asked most of my questions, but I did want to ask, yeah, I guess in agreement with everyone else, since the question or the matter is basically if April 2nd is the legitimate convention. I guess I'm just confused why to the Imhoffs, if the body suspended, the bylaws, which is something we regularly do in meetings and everyone agreed to it, I guess I'm just unsure why there's a lot of backtracking. It seems like that was the will of the body at the time. And then also, if you confirm that convention was invalid, you also, I guess, just for the record, are confirming that the delegates that you sent to national were also illegitimate?
Okay, first of all, no, the delegates are legitimate. The legal law in Idaho does afford for a meeting to be held to elect delegates if it happens prior to elections.
Okay.
And so that, again, that doesn't change that. And but to answer your first question, we don't know who the county, the precinct men are until May 17th. We don't know who's going to be elected. We don't know who's going to be comprised of that board. So on May 28th that we received those meeting minutes, that's what validated that we had to redo this, because it wasn't just that these existing bylaw members decided that they were county chairs. They also went ahead and started to appoint non-members and also Republicans to the state central committee. So now we suddenly have a state central committee that is including additional people. The state is not required to inform the state party who precinct men are running. So once I received those meeting minutes, we had to, as a board, start calling every single county to figure out who's running and who won. That's why conventions are not held prior to primary elections being done. And this is the first time this has ever been an issue. All previous election or conventions in Idaho were held after June.
Okay, thank you.
Okay, any brief comments from Mr. Sorensen or Losby in response? If not, we're going to move on.
Madam Chair.
Yes.
May I respond just on a couple of matters here?
Yes.
That I did notice.
Yeah,
Nothing. Okay.
Keep it brief.
Sure. Nothing in the bylaws requires that the convention wait or be held after the election of the county committee, of the precinct committeemen or the county chairs. The requirement, there is basically no requirement in the bylaws for it being dues sustaining members or anything such as that. It is very, very vague. I think to the point where I, as somebody living in Philadelphia, could technically be elected to that position. I am not certain of that. I'm obviously not campaigning for it, but I think that they could technically elect me as a member of the Libertarian State Committee from some county.
Okay. Thank you very much. Let's go now. We're going to go to Mr. Nana and then Ms. Harlos.
Okay, I'm going to try to be brief, and I would request the responses be brief as well. So my understanding of the bylaws is that your bylaws say that it needs to be held in the last 2 weekends, or the last 2 weeks rather, of April, or in accordance with state law. State law then says it can happen at any time. The or clause means that effectively that first part of the bylaws is moot, because as long as it's in accordance with state laws, it's fine. Where is the disconnect here with the argument that somehow this is an illegitimate convention? It sounds like, to me at least, that it was just poor planning, and that it would have been nice had you held it later on after all these elections for precinct committeemen or whatever were held, but that it wasn't, and that in fact it's still legitimate even still.
So I think if Todd Crissetti had came to the executive board and said, hey, I'm a precinctman and I want to start a county, prior to appointing people into the state central committee, then we would have been working within what you're saying, where all of those people in question also are in that Venn diagram of being existing members. It most likely could have been worked out, but by them appointing non-members and Republicans, suddenly we're looking at a much bigger issue. That means we have to respond quickly to understand who they're appointing. And we also have to,
Madam Chair, that's not answering
This
Mr.
is not
Nana's
germane-
question.
Yeah, this is not germane to my question, and I specifically requested very specific answers. I'm going to ask again. So this April 2nd convention, according to my knowledge, was held legitimately with. What exactly is the reason you are saying that this convention was illegitimate? That is all I want to know.
because it didn't take into account the legal requirements of including all central committee members as elected by the primaries.
But they were already elected. They were already elected people. They were neglected to be elected previous to the convention. There could have been people in those places, but there weren't because they were vacant. Is that correct?
Yes. They were vacant. Nobody was in those positions.
Okay, thank you.
Ms. Imhoff, I'm so sorry. I'm taking notes. Could you repeat what you said? Just 1 second, because my mouse froze. You said they didn't take into account all, and then something about elected people.
They didn't take into account all the precinct men and county elected committeemen.
Got it.
Which are required by the law to be included in our convention.
Okay. Thank you so much. Okay, any brief comment from Sorensen, Losby, or JJ?
Madam Chair,
Yes.
I wanted to be clear here again. There is no requirement
Okay.
under the bylaws to wait until the committee people are elected.
Okay, how about the law?
I know of none, but that does not mean anything. There has been none that I have ever seen cited.
Okay,
I think it would be
thank you.
incumbent upon Ms. Imhoff to cite that particular statute.
Okay, thank you very much.
We can
Ms.
pull that law up if you give us a second.
Yep, I think we're going to move on in questions, and then if you can drop it in the chat, or we'll just come back to you, I will make sure to grab that from you.
Okay, thank you.
Okay, so let's go to Ms. Harlows.
And again, I probably will raise my hand again to get back in line, so I do not want to monopolize time. But I have to say, Mr. Nana nailed it. We are going really off on rabbit trails here. Really, the issue here is, was the April 2nd convention valid? I've seen no reason why it wasn't. That bylaw, as Mr. Nana so aptly stated, says it either has to be the first 2 weeks of April or accordance with state law. State law says it can be held at pretty much any time. So it was in accordance with state law. There is these vague assertions that it has to be after a primary, but it was after a primary. It was after the primary in 2020. What I believe the Imhoffs are doing here is they are citing that some potential future office holders are being excluded. But that's not the way things work. The only people that can be excluded from rights are people who presently have rights, not people that might have rights after some future election. So even claiming that it had to be after a primary. It was. The fact that nobody was elected in 2020, them's the breaks. So nobody was excluded that had rights to be included in April. To try to push this off to a time when other people may have rights is completely illegitimate. As to the question of, oh, well, why don't we just let the members decide this? And the members have decided this. You can't just keep relitigating something. And the ultimate interpreter of the bylaws is the members in convention. They were aware, quite obviously, that there might be a question as to the scheduling of this convention. They decided it was okay. You know, they're allowed to decide wrong things. And if the Imhoffs believe they violated the law, then the burden is on the Imhoffs to take them to court. But the final court of arbitration within the party to settle things in the party is delegates and convention. And the delegates and convention have already decided this. And it seems to me that a prior board is trying to seize this decision back. And they just can't do that. No valid reason here at all that wasn't already considered by the delegates has been presented for invalidating the April convention. It seems crystal clear to me that the April convention was in fact valid. But I do have some questions. First, a comment. No matter what happens here, please get a parliamentarian to go over your bylaws. They are not good. Now, here's my question. There's this hybrid convention scheduled. I don't see any authority for hybrid conventions in your bylaws. I see something that says when the convention is in person, it needs to rotate between regions, which kind of sort of implies it might not be in person. But Robert says that electronic, you know, to hold a convention electronically, it has to be explicitly authorized in your bylaws. And it's not. So I don't even think this August convention is valid unless there's some kind of emergency order or some other law in Idaho that hasn't been cited. So I'd like to know the authority. That's a question I have for the Imhoffs or someone they wish to speak on their behalf. What's the authority for holding a hybrid convention?
Oh, Robert and Jennifer Imhoff, if you or anyone would like to speak on your behalf. Go right
We're looking
ahead.
right now. Stand by.
Okay, no worries. We'll hang tight for a moment.
And that wasn't the only point I had. So while you're looking, I'll just continue and just let me know when you have it. I have said this in every single matter like this that has come before us. The elections that happen at a convention are presumptively valid. It's not an unrebuttable presumption, but a very high burden of proof is upon those who are challenging it. And I don't think that's been met here, that we need to go with the presumption of the people in Idaho who have already decided at their April convention who their board is and who their judicial committee in fact is. I will say, however, that and this would be up to Idaho to decide, I'm adding this almost as an aside, that I do disagree in one sense. It doesn't make a difference here with the attorney/parliamentarian's opinion, and I don't know what Mr. Jacobs' opinion is. I do think your executive board are voting members of your state central committee. In order, it says they're members of the committee. Inherent in Roberts, in the definition of being a member, is voting rights. In order for someone to be a member of something and not have voting rights, they need to be explicitly excluded, not specifically stated. So I do disagree there. I do think your executive board are voting members of the state central committee, but that also cures the other, which I've seen alluded to, because I've seen two arguments for why the April convention wasn't valid. One is that it needed to be after the primaries. I don't see any weight in that at all because it was after the primaries, the 2020 ones. But the other argument I've seen is that the people who called the convention had no authority to do so because there was no state central committee. I think there was. I think your executive board are voting members of the state central committee and had every authority to call that April 2nd convention. I'm waiting just to see about the hybrid thing. I'm willing to let other people talk. I'll get back in line whenever that
Section,
answer.
Article 5, Section 4 says that quorum shall be established by counting all physical and remote delegates credentialed at the time of a call to order. That's a very explicit in here.
All right. I don't think that's as explicit as Roberts requires, but that does satisfy my question. And it also solidifies my opinion that your bylaws aren't very, they're not good. But thank you for answering that. That was more of a curiosity because I've already pretty much, I think, said my opinion that the August convention is invalid because there's already been a convention, whether hybrid is valid or not.
Okay, thank you, Ms. Harlos. Imhoffs, we're going to come back to you when you're ready.
Sorry, ready for what?
Let's see, it was to answer, there was a question, about law. There was a particular law that you were citing that said that didn't take into account all the precinct men and county elected committeemen, which are required by law.
I can't find it in the snap second here. We're still looking, but what we can tell you is that it references that delegates shall be in charge of hosting the convention. It's somewhere near 34,707. I'm just having difficulty finding the exact one, but it speaks to that. According to Idaho state law, the delegates, i.e. people who are state precinctmen, their sole purpose in the state of California, or excuse me, you're from California, I had that on my mind. The people in the state of Idaho, the delegates of Idaho, their sole responsibility is to organize a convention and nothing more.
Got it.
So state central committee members, so a precinctman, which Corsetti is, like the only privileges he's given according to state law is that he can call a convention.
Got it. Okay, if anybody else comes across that law, it might be near Idaho statute 34-707. I flipped through it. I haven't seen it, but obviously I am not as familiar with it as everyone else might be. So we'll just
Madam Chair, just so you know, in all the documents that were submitted to us, I pulled out every statute that was referenced and it is in the OneNote.
Oh yeah, I looked through the whole OneNote.
Yeah,
I've read all the statutes and done additional research.
Okay, I do not believe that's a requirement. I have as well. And I would assume that the attorney who gave an opinion had as well. I do not believe that's a requirement.
Well, if it's out there and we haven't seen it, maybe it'll materialize. But no, I haven't seen it yet either, and I did some legal research. Okay, so let's move on to Mr. Connor Nepo, and let's also be mindful that we're coming up on 2 hours. Granted, we did get a little bit of a late start, but we're coming up on 2 hours. So after Mr. Nepo's line of questions, I'm going to sort of read the room, take an informal survey, and we're going to see if we need a break or to keep going.
Well, Madam Chair, I was going to motion if Mr. Nana will permit me to have a 5-minute recess.
Is that it?
Yeah, posted in there. And also posted in there 34-624A.
Guys, you are unmuted, but we can hear you, but that's probably good if you said 34.
Someone said something about a 5-minute recess and I thought I heard my name. I don't know. I'm just walking in.
Yeah, I would like to motion a 5-minute recess if with your say so, Dustin. As your alternate.
I'm amenable to it. What is the do we think that like people just need to use the restroom or something, or
so let's find out right now. I want to be respectful of the people who are on the call who are not LNC members, but can I get a show of hands of LNC members, just LNC members who has additional questions? Use the hand raise function so I can get an idea of how long we're going to keep going, because if we're going to have a recess, obviously we're only going to do that if we're going to keep going. So Ms. Harlos does. Anybody else? Anybody else? Okay.
I would like to hear, I know there's some people on the call who would like to jump in and add additional commentary, but
Okay, so how about this then? Anybody want to give public comment for 1 minute at the end? And I'm going to also give at least 5 minutes closing to the Sorensen and the Imhoffs. I want to see your hands raised with the hand function so I can make sure that I get everybody, because I can't see everybody's faces on the screens. Because I know some of you have wanted to speak and I know you've been frustrated and I want to give you a moment. I see at least 2 hands. Okay.
I thought there
Here's-
was a motion for recess on the table because I do need to
Okay.
do a human function.
They wanted to check first to see who all was going to talk. Okay, so we can do a 5-minute recess. I was just going to let you stand at ease. How about this? Why don't you go ahead and make your motion? Let's get a second, and if there's no objection, we'll do it really quickly.
like
Yeah,
to,
he can. Yeah, go ahead.
I'd like to motion for a 5-minute recess.
Okay.
I'll
Callan
second.
seconds.
Okay. Any objections for a 5-minute recess? Going once, going twice. Hearing no objections, we're going to have a 5-minute recess. We're going to be back in exactly 5 minutes. For Pacific time, that would be 7:03. For East Coast time, that's 10:03. Please keep yourselves muted and please be prompt. Run for the bathroom, cookie break, cigarette, water, whatever. Okay, we're about to come back. Got just a few seconds. Ms. Harless, are you back?
Yes, I am.
Okay. You had a question. I think you can go ahead and ask that now.
Hold on one second. I need to, I see the statutes that Mr. and Ms. Imhoff have put up on the screen. They're the same ones that are in the OneNote. They don't say what was claimed to be said. One thing I'm seeing going on in this meeting a bit, I don't view lawyers as the priesthood of our society where we can't even decide anything without a formal legal opinion. While there are some things that are ambiguous in these laws that would require a legal opinion, which only one side has gotten, most of it is fairly clear, and none of it has said what's been claimed. And I think most of the issues that people are claiming are legal issues. I don't believe they are. I believe they are bylaws, interpretation, and parliamentary issues. Those sorts of things, I'm fairly confident of my position on. But one thing I'm absolutely confident on, even if they disagreed with me, is that the delegates in convention are the ultimate authority. And the delegates in convention on April 2nd realized some people might have an issue with the date. And they said, this is in conformity with our bylaws. And part and parcel of that is the delegates in convention saying, we also believe it's in conformity with state law, since state law is incorporated into their bylaws. We do not have the authority here to override the will of those delegates unless there was something that could be proven to be a continuing breach of the bylaws, which has not at all been established. And the burden, what I'm getting to, I'm sorry, it's a bit long-winded. I think the ask is actually backwards. I actually don't think the LNC needs to do anything. I think the LNC always presumptively recognizes a convention and the change in leadership that happens thereof. I think the ask really is that the Imhoffs are asking us to declare that convention invalid, because otherwise our practice is that each state party carries on its business and we recognize the results of their annual convention. I actually think the burden is upon them to get us to overturn that convention in some way. But as of right now, walking out of this meeting, as far as I'm concerned, without even any kind of motion, though I wouldn't mind resolving this to clear it up for the members of Idaho, the board that was elected at the April convention is the board. That is our Idaho affiliate, along with any of their valid successors.
Thank you, Ms. Harlos.
Wayne, can you please shut the door?
Very nice. So,
oh, sorry.
I want to give the Imhoffs a moment to respond to that, and then I just want to clarify with them. I see they dropped something that says section 4 in the chat. And then I see two other things. We've got Idaho statute 34-505. And then I see 34-624A. If the Imhoffs would, if you have any response to Ms. Harlow's comments, and then if you could just let me.
Are you asking us to respond to her opinion there?
If you wouldn't mind.
Sure. I mean, what we're outlining in the chat there,
Yeah.
and the discussions that we've had directly with the two separate deputy secretary of states of the state of Idaho. They're not lawyers. They're just telling us what the law says. They're not giving an opinion on the law. They merely say, this is what the law says. So we asked them several qualifying questions over hours of conversations in person. And the key takeaway is that there are state central committees that can be formed through people who get elected to precincts. But at the end of the day, what these outline is, they say what is qualified as a delegate to attend a convention and to call conventions. But in the eyes of the law, that's basically all state central committees do, is say like, here's the people who call conventions and here's how they formulate the rules. And they formulate the rules through our convention bylaws that have already been in place for 40 years and modified therein. So, I mean,
Okay.
you're correct. This is not a law thing. We concur with Ms. Harlos. This is a bylaw thing. So all that's happening here is we have to reiterate, like, this whole rollback thing was like, you know, for 40 years we've had our conventions after the primaries. The Republicans and Democrats continue to have their primaries after. There's a misnomer in our bylaws that says or instead of and, you know, and that's a special legal thing. I won't get into that. But at the end of the day, we're not doing anything. We're simply just trying to redo the convention, and it might shake out the exact same way as it did before. And then that makes all parties whole. We're like what is it we're trying to accomplish? I think that's an important thing nobody's asked us yet. Like, what have we been doing between June 1st and today? Well, we haven't been funneling money around. We haven't been doing fundraisers. We haven't been hosting special candidate camps. We've been doing nothing but trying to get this convention redone. So like hijacking and taking over and redoing what? Just to do a redo? I mean, like what's you see what I'm getting at there? So that's the only retort I would say is like what is our ulterior motive here, to just redo the convention after the primaries? What more than that are we trying to do here?
Gotcha. Okay, thank you very much to the Imhoffs. Okay, I see Dustin Nana's hand is up. I see other people have their hands up. Just hang tight. When we get to public comment, I'm going to call on you.
We'd also like to acknowledge Joe Evans to speak for the party. He's been waiting to speak.
Okay, that's actually totally fine with me. Dustin, if you don't mind, let's hear from Mr. Evans first.
Yeah, no, absolutely.
Okay, thank you for the time, Madam Chair. Appreciate the opportunity to speak here. One of the key areas of contention here is a procedural issue. Now, this comes down to the state managed election. Between early February, mid-February, we called the convention for the April 2nd date. We made the appropriate adjustments within committee in order to call the convention, making allowances for the time because there were issues. Now, following that convention from February 28th until March 11th was the time to register to be part of the state managed election for precinct committeemen. Following that, we had the April 2nd event. Then we had the May 17th election. Now, the May 17th election isn't completed on canvassing until May 24th. Okay, at May 24th is the earliest opportunity for anyone in the party to realize whether or not anybody's actually been successfully elected. Now, between the 24th and the 28th, well, actually between the 19th and the 28th, several individuals submitted minutes to the meetings. Now, as Matt Losby has pointed out, Mr. Losby, 4 of those 5 individuals were present at the convention and failed to mention that they had intentions of submitting minutes where they declared themselves by committees of 1 as precinct committeemen. Now, that is ultimately what caused the board, the 4 members that were involved, that voted to reinstate, and the unilateral acceptance of the previous board, a vote in and of itself to accept the rollback, because we would have to accept taking back the positions. Now, this creates the problem with the procedural issue, because with that April 28th minutes being submitted to the board, we were no longer able to operate on bylaws because we were forced to operate under state law because the state ran election was being authorized, was being called in primacy over the bylaws. Now, this is ultimately where my position stands on this, is there would be no problem if it wasn't for the fact that rather than working with the current board to acknowledge their positions, they demanded recognition of an election that was in process at the time the convention was held. And they did it in an extremely harsh manner. Now, from a procedural point of view, as JJ is probably going to have to comment here shortly, this represents significant problems because we're now stuck in a paradox. The people who called asked that the state election law be primacy in determining the nature of the central committee, the state central committee, didn't have all their I's dotted and T's crossed when they made the claim. Thank you.
Okay, thank you, Mr. Evans. If we could hear briefly from Mr. Jacobs, he has his hand up.
Yes, please. I just wanted to make sure that I have this understanding correct. The 4 people that were just mentioned who had thought they were elected, submitted minutes, and then realized that they did not have the requisite number of votes, which is quite possible and has happened to me, something like that, basically withdrew their claims to be members and did not vote and did not attempt to claim to be committee positions or to be elected to the board. They all voluntarily withdrew that. Is that correct?
They did that after we initiated the rollback because they were not aware until June 1st. Read the letter from Matt Losby to the board as well as to Miss Mara, who was the Ada County clerk. At which point now there are, what, Matt, have you got like 3 or 4 exchanges with the Ada County clerk prior to coming to the understanding that your signature as the Ada County Central Committee chairman was improperly formatted before you finally submitted that one particular that is now a matter of record, that definitely not the Ada County Central Committee chairman?
Okay, so I'm going to ask, what's the bearing of this on whether or not the convention was valid?
Reason was because this was a claim that created primacy of election law over bylaws. Once we instituted the requirement that election law be recognized, which we had to go through and do a significant amount of research to understand what did and did not happen and whether the I's and T's were indeed dotted and crossed appropriately. We had several individuals that already improperly filed paperwork with county clerks, made claims improperly with county clerks as to their status, invoking state law, which overrode our bylaws, which a certain amount of our bylaws are literally copy paste directly out of state law.
Okay, I see that. Let's hang tight for just 1 second. I see that the Imhoffs have their hands raised.
Yes.
I know that Jonathan Jacob has his hand raised. Dustin, Nana, and Karen and Harless have their hands raised. I'm trying to get a read of the room on LNC members and how much more questioning we want to do, because I don't want to cut off the parties, but I want to start kind of figuring out where we're going with all this. Ms. Harless, do you have more questions?
I do, and I know, and were you calling on me or you weren't
I
calling?
was just kind of checking. I just want to make sure that you did have questions. I'll come right back to you. Dustin, Nana, did you have questions?
Pat has his hand raised, but I would like to be in line behind him.
Patrick Ford has his hand. Oh, I see. Okay, so I want to give the
Madam
Imhoffs-
Chair.
Yes.
I don't want to be inadvertently deceptive. I have comments. They might not necessarily be a question, and I have a motion because I see some LNC members are wanting to adjourn, and there is a motion I wish to make prior to adjournment, and a type of motion that would be allowed at this meeting.
Okay. Okay, so here's what I'd like to do. I'd like to hear from Pat Ford because this is the first time he's had his hand raised. Before we go there, I want to give the Imhoffs just a minute or two to respond because I know that they had something to say and I don't want to cut them off. So
I'll keep this real brief.
Yep.
I just wanted to acknowledge that, yes, they did retract that message to the rolled back board. So they sent an email to the rolled back board saying, yes, we did this as a mistake, but can you still please acknowledge? And I think it's important to note that they did acknowledge the rollback board at that time. And it wasn't until we denied that request that they decided to move forward with their rogue board. It should also be noted that they did not retract that message with county clerks. And it's those communications that caused much of this kerfuffle.
Okay.
Yeah, and just the final point is to glue together what Joe is saying with everything that we're saying. This board in April 2nd could have been left alone, and then everybody try and reconcile elections and bylaws together. But it was people who were attempting to seat 2 Republicans as libertarians in these meeting minutes that were like, we can't do nothing. We have to talk to the Secretary of State and understand what the law is, because you have to be a libertarian for 6 months to even be considered a delegate. That's state law. So they advised us that they can't give us any legal advice. And we said, well, we can just simply have the election when it was supposed to be after that. And they're like, we won't stop you and we can't tell you if it's right or wrong. So they understood why we rolled back and what we were trying to accomplish. They obviously can't weigh in legally on it, but we gave them qualifying questions about the law to make sure what they wrote and what they can give opinions about the law on. They didn't see any law reasons why we couldn't redo the election after the convention after the elections.
Okay.
Does that make sense?
I am trying to follow it and just taking notes as best as I can. So one of the things that's getting a little bit confusing is when one party represents that another party said something else. And then in the chat or somewhere else, they're like, no, that's not true. That's not what we said. So I'm trying to avoid that. I don't want to get into a long back and forth here. It's sort of like, it is.
I do apologize.
It's okay. I know.
I'll try and mention things as what a document says. So I'm only referring to what a document says, not what a person said. So a document said, we want this Republican seated as a libertarian, and we took exception to that. Okay.
Sorensen board, do you or anyone on your behalf have a quick reply, and then we got to move on to Mr. Ford. If you wanted to have someone else speak on your behalf, that's fine. Let's just try to move quickly.
I'll just say very briefly, there is no requirement for bylaw sustaining membership to be appointed as a state committeeman or state committee woman. And so that would not cause any action whatsoever or any change in the structure of the party. And also, we can't do nothing is not a justification for any specific action, especially when there has been no meeting with notice of the executive board.
Okay, got it. Okay, so let's jump over to
Quick question. Russ statement.
We need to jump over to Mr. Ford right now. I'm so sorry. Okay, Pat Ford?
Yes, Madam Chair, can you hear me okay?
Yes.
Very good. I'm just going to take up about a minute of the board's time to briefly editorialize. First of all, I stand with Ms. Harlows and Mr. Nana and other members who have, quite frankly, brilliantly, have pared down the actual issues despite all the surrounding noise and drama to the central point of the legitimacy of the April convention. Editorializing. Folks, you had me when someone invoked FBI. I got to tell you, short of outright true fraud and violence, the notion that libertarians would invoke the power of the state in the form of the FBI of all organizations against potentially and weigh that against other libertarians makes me physically ill. We seem to, over the last year or so, no fault of anyone completely, but I'll say in general, have lost track of the true mission of the Libertarian Party, which is to bring liberty to all of us, and the totality of the efforts surrounding this and other relitigations of legitimate elections of board and member positions and offices, and over the last year and a half has obliterated, I got to believe, in the aggregate, thousands of hours of man time, labor time, liberty time. Folks, I just want to remind folks that you don't need a title. Yes, a title can help you fight for liberty. But if a third of the energy expended in all the states mentioned tonight have been instead directed towards a fight for liberty, as opposed to these endless libertarian Game of Thrones, I'd like to say that we would be in a much better place with regard to the Rona and to the issues surrounding inflation and to any one of the other issues attacking us. So I would just beg people at a certain point to think back to what's important. I'm one of the older guys here on the board, and to me, it's all about opportunity. We've got wonderful people in a critically important cause, and if you're a little older, you may be understand that the chemistry that's involved in bringing people together to fight big issues like this, to fight for the big issue, is so hard to pull together, that this type of collaborative nonsense over the last year and a half is just an incalculable waste of time and people and energy. So I'm begging people who are listening to this or might be discussing this in the future, let's move our eyes back to the real enemy, the real game. And that's fighting the government, fighting the duopoly. You know, again, you had me at FBI. I know where I'm going to vote already. And I would just urge people to let's step back and look at what's important. Thank you, Madam Chair.
Thank you, Mr. Ford. Okay, Dustin Blankenship has his hand raised for the very first time. Dustin, do you have a long line of questions, or did you have like brief?
I have one question.
Okay, let's hear it.
And especially going after that beautiful oration, I would welcome you to rule this dilatory if you feel so. But I had one piece of curiosity that had not been touched on in the conversations, and it's been referenced multiple times that that there was an attempt to appoint Republicans, but there was also a reference to individuals could not do the role if it was within 6 months of becoming libertarian. I was just curious, were these individuals actually registered as Republicans at the time, or were they individuals who had switched parties but did not meet the maturity requirement of the 6 months?
According to our records, they've always been Republicans and still are. They all voted in the primary election as Republicans.
Okay, so Mr. Sorensen, do you have any response to that? But also more importantly, is this pertinent to the April 2nd convention?
No, my hand wasn't raised about that, but no, I don't. It doesn't have any bearing on the legitimacy of the April 2nd convention.
Okay. Okay, so Ms. Harlos?
Okay, thank you. Once again, I'll say, I've been looking at each of the laws cited, and none of them say what's been claimed to have been said. Originally, when the question was posed, why would we do this? Why would we go through all of this trouble to have another convention? And I wasn't even going to go there, because I really don't think motives or why really matter. The convention is valid or not. But from the time I wrote that in my notepad, all of a sudden, a bunch of motives have come out, that they didn't like that certain people kept to themselves, that they were going to form county committees. There's no requirement in the bylaws that they tell everybody. That might be rude, that might be sneaky, that might be not someone you want to work with. But it seems to me motives are starting to come out of some kind of personal animus that's going on, and that's not a valid reason to invalidate the convention. We're going down rabbit holes where the word Republican keeps getting thrown around like red meat, because, you know, say Republican to Libertarian, obviously that's going to irritate them. But it's irrelevant, because none of those people, all of those claims got withdrawn. Were they bad claims? Should they not have done it? Yeah, probably. But they're completely irrelevant to whether or not the April 2nd convention was valid. It's just chum in the water that's a distraction. And I really wish we would get around that. I mean, get away from that. But if we want to answer the question why, I would refer everyone to, even though I'm not a fan of expulsions, to the opinions of the Judicial Committee ruling on the requests for expulsions. The people in Idaho, the Judicial Committee in Idaho, gave their reasons for why they think why. I'm not endorsing it or not endorsing it, but that's who, if you want the answer to the question why, Idaho has settled that whether I agree with them or not is not before this body. This matter has already been decided by the delegates at the April 2nd convention. Absent again, wait, I'm just looking at my notes. 1 second here. Oh, I've seen mentioned a couple of times again, and I think this is more chum in the water. While these were committees of one, this might seem weird to people, but parliamentary wise, committees of one are allowed. That's really not even that unusual. So I don't know why that keeps coming up. Those other people, I agree, did not validly form committees because they didn't get the required 5 votes. But I firmly believe that Mr. Corsetti's chairmanship is valid. Mrs. Corsetti's state committee woman position is valid. But again, those are somewhat side issues. The April convention is really all that's before us, and the board that came out of that. There's a lot of side issues here that Idaho is going to have to resolve within itself that are nowhere within the purview of the LNC. The only thing before us right now is who is the legitimate officers of the Libertarian Party of Idaho. The April 2nd convention decided that.
Okay, thank you, Ms. Harlos. I think if you're finished, we're going to move on to Mr. Nana. Okay.
At this point, I would like to make a motion to adjourn the LNC portion of this meeting and move to public comment.
Okay,
Seconded.
who seconded?
That's me, Joseph Eklund.
Thank you very much. Okay, it's been moved and seconded to adjourn. Any objections from LNC members?
Yes.
Okay.
But my objection could be cured rather quickly. And that is, I forgot to say one thing. I'm going to be, and this might get everyone to agree to adjourn. I'm going to tell you my intentions is I don't think we need another meeting on this because I don't think any evidence has been presented that the April 2nd convention was invalid. I intend upon moving on the email ballot, and unless an LNC member objects and would rather have a special set meeting, I'm amenable to that. A resolution that I don't even think we need to make, but I want to make it to clear the record that the LNC recognizes the elections of the April 2nd, 2022 convention and their valid successors as representing the Libertarian Party of Idaho. I will be moving that on the LNC list. If somebody would rather do this at a meeting, please make that motion, but that cures my objection to adjournment.
Okay. Okay, so it's been moved and seconded.
I would object to deciding the case right now, Brian Elliott.
So we are not deciding anything. We are just, the only thing that's at issue is adjourning the meeting, and then we're going to go to public comment.
Oh, I'm sorry. I misunderstood Ms. Harlos's motion. Could you repeat it, please?
Oh, it was no motion, Mr. Elliott. I'm so sorry. We can't decide anything now anyway. This is a special meeting. No motions were noticed. I was just informing the LNC of my intentions.
Understood. Thank you. Understood. Thank you.
Yeah, that was it.
Any further objections? It sounds like both are withdrawn. Going once.
Correct. Withdraw.
Going once, going twice. And I'm going to say that we are adjourned at 7:33 p.m. but we are going to hang on for the purposes of public comment. So if you've got public comment, get your hand up. The first person that we are going to call on is Dan Carlin, because he has patiently had his hand up the whole time, and we have not heard from him yet. So Mr. Carlin, take it away.
Thank you very much, Madam Chair. I would like to address one point specifically. My name was brought into this discussion practically incidentally, but in favor of the position of the Imhoff board. And I would like to set the record straight. There was a regular meeting of the duly elected board on May 24th. That was the last time that board was called to order by the chair elected at the convention. Subsequently, many of us dispersed to regather at the national convention. When I returned from the national convention, I saw in my email box a document which was apparently a declaration of the retro board, the old board, taking effect, and a statement that to the effect that this organization had filed the paperwork with the Secretary of State. The curious thing is, if there was a meeting at which that was decided, I was not present. And as secretary, you would have expected I would be. And in fact, my name as the secretary or the officer of the party was not on that document, which listed Ms. Imhoff, Aaron Mason, or maybe not Aaron Mason, and the others of the Imhoff board. So it's particularly curious, without a secretary, can a meeting that which therefore has no minutes be legitimate in and of itself? But for the purpose of a point of personal privilege, I just want to make it clear, I knew of no such meeting. I did not attend such a meeting, and to offer in evidence that I would have supported such a resolution is a mistake. Thank you.
Thank you very much, Mr. Carlin, and thank you for your patience throughout this meeting. Let's go now to Jonathan Jacobs.
Madam Chair, I'm wondering if you could advance Mr. Phillies ahead of myself. He has been here longer, I believe.
Sure, absolutely. Mr. Phillies?
I'd like to go back then.
Hello, can you hear me?
Yes, absolutely.
Very good. In that case, my advice to the committee is, in any issue of this sort, there are two sorts of questions. There are rules-based questions and there are political-based questions. The LNC has in recent times focused on rules-based questions and ignored the political question of what is going to advance the party. I would suggest, and I'm sort of repeating what Pat Ford said, that your correct decision is to note that Idaho has a whole lot of candidates. The two groups should be told to get out and support those candidates and come back in December and justify by what they did who you should choose as the affiliate, whether it happens to quite agree with rules or not. Getting buried in what convention was valid or not, it's not a rabbit hole. It's going to wear out a couple of atomic earth borers trying to reach the bottom. Thank you.
Thank you, Mr. Phillies. Jonathan Jacobs?
Madam Chairman, yes, I wanted to first of all state that while I have provided information to this, I was not party. As far as I know, any information of mine was not used in the disciplinary action. There's also a typo on there that said that there were points of order raised at the, in my opinion, at the April 2nd, 2022 meeting. There were none. I did check. Nobody did object to this. And on the third point, which I would like to, which I will have to disagree with the previous speaker a bit, I would encourage you to resolve this one way or the other. For this, by motion, for the simple reason that it will give whatever side does not prevail the chance to appeal that decision. It will become an action of the board. And I would like to see whatever side loses this have appellate rights if necessary. Thank you.
Thank you, Mr. Jacobs. Next, we're going to go to Nathan Madden.
Unless I missed something,
The bylaws of the Idaho LP does say that the regular convention has to be within the final 2 weeks of April. Unless you follow something with election law. But from what I can read in all of the cited election law, there's nothing here that fulfills the requirement for April 2nd to be valid, because as was stated before, and again, unless I'm misunderstanding, there was no SCC prior to this election that happened this year. Is that correct?
We're just doing public comment. We're not doing Q&A right now. I'm sorry. Okay. Any other public comment? Karen Ann Harlos, I see your lips moving, but you are muted. And
Yeah, I got in line for public comment because this really wasn't LNC type comment.
Okay, go right ahead, and then it's going to go to Mr. Evans.
Okay. I have friends here on both sides of this. This has been an extraordinarily difficult issue here. And I hope everyone here remembers we're all libertarians and friends. And this is now just as a party member, not as an LNC member. I encourage the Sorensen side. I know you're not going to like what I have to say. I encourage you to reconsider the expulsions. Expelling people, it never leads to good things down the road. You could take what I have to say and ignore it. I'm just telling you something from my heart. I think I'm channeling a little bit of Mary Ruwert here, and try to work things out. I would agree with Mr. Jacobs. I do think, and this is one reason why I am going to be offering a resolution now. I'm putting my LNC hat back on, because the other side does deserve appeal rights. And if there's no decision of the LNC, there are no appeal rights. And I, for one, on any decision that people feel really strongly about, I welcome an appeal. I don't view that as hostile whatsoever. They are there to protect members' rights. And lastly, Dan, it's been a long time since I've seen you, since Little America, I think. And it's so good to see you again.
Okay,
I saw you at the convention.
Oh, that's right. I'm thinking of that wonderful with Martin. But anyway, it is so good to see you. I'm so glad you came.
Okay, last person in line for public comment is Mr. Evans. So I just want to remind everyone, when we do public comment, it's like 2 minutes and then that's it. We're not going to keep repeating. So I don't want to hurt anyone's feelings, but that's just the format. Mr. Evans, go right ahead.
Yeah, a quick address regarding the State Central Committee. In the last 40 years, there has been a continuous status of the State Central Committee. The Executive Committee is indeed an elective body with voting rights in every State Central Committee meeting and functions as the sole members of the State Central Committee in the absence of precinctmen, county chairs, were elected by the body. And yeah, that's fine. I got issues with regards to some of the minutes of this current Central Committee, as they believe they have been formed. Again, debates regarding that, not relevant to this issue. Not relevant to this discussion. For those of you who are interested, I am available for questions at any time after this. Thank you.
Okay. Thank you, everyone. We are done. Ms. Harlos, you can end the meeting as soon as you're ready.
Okay, yeah, I will 3, 2, 1, I'll be ending. Thank you everyone for your time this evening.